Good afternoon, everyone. We'll go ahead and get started, and other guests and audience members will join us as they can. My name is Damon Hewitt. I am President and Executive Director of the Lawyers Committee for Civil Rights Under Law, an organization founded in 1963 at the behest of President John F. Kennedy to leverage the private bar and to serve our now contemporary mission as a racial justice organization to bring the voice, the opportunity, the power so that Black people and other people of color can help to make the promises of our democracy real. Today, I'm so pleased to have with us special guests for our discussion about voting rights and about democracy. Our title is Democracy on the Line, Racial Justice and the Fight for Voting Rights. It seems that we could have this conversation every year, year in, year out, not just in an election year, and not just in a year in which we know currently, just like last year and also 2021, that democracy itself has been under attack. We saw violent attack at the US Capitol on January 6th of this year, which is the subject of one of our lawsuits at the Lawyers Committee, Smith v. Trump et al. It's also important that we see voting rights and democracy under attack in states across the country through these voter suppression bills, that the flood of them that have been adopted or proposed in various states, which have also been the subject of litigation by the Lawyers Committee, by colleagues at other organizations as well. And it's an all hands on deck fight. But we're also fighting on the front of public narrative, the notion about who's deserving of access of the ballot to vote. We know historically who's been denied access by chattel slavery, by statutory demands, by intimidation. Some of that continues to this day. And we saw it even in the last presidential election, and of course now with the voter suppression bills. But we have been fortunate to have not just organizations like the Lawyers Committee, but great allies in platforms and positions of power to help to stand in the breach and to stop these things from happening. And we have with us today guests who have been on the forefront of that fight. We have a two-part discussion today. First, we'll be joined by Congresswoman Terry Sewell from Alabama, who I'll introduce in just a minute. And we'll also be joined by guests who will give a view from their front lines in Texas and Georgia, respectively. And of course, our great colleagues at the Lawyers Committee, our co-directors of our Voting Rights Project, Ezra Rosenberg and Marcia Johnson Blanco. But first, let me turn to the federal landscape. And I want to introduce our first guest, Congresswoman Terry Sewell. Before I do, let me just remind the audience, as you may have seen in the instructions emailed to you, if you have questions, please note them using the Q&A function, not the chat, but the Q&A at the bottom of your screen. That will allow us to stack questions, and our guests will be able to answer in that way during the short Q&A segments. And also, we're using captions for those who need them, who may be assisted by them. So please take full advantage of that. Welcome, Congresswoman Terry Sewell, to this gathering. Congresswoman Sewell is in her sixth term representing Alabama's 7th congressional district, known as the Civil Rights District, which includes her native Selma, Alabama. She is the first woman elected to Congress from Alabama in her own right, and the first Black woman ever to serve in the Alabama congressional delegation. She, of course, sits on the exclusive House Ways and Means Committee and brings to that committee her more than 15 years of experience as a securities and public finance attorney. Very impressive. Currently in the 117th Congress, she serves again on Ways and Means, and she serves on 3 subcommittees on health, on select revenue measures, and also Social Security, all critical issues for the human infrastructure of our nation, which is so at issue today. In a short time, a relatively short time in Congress, Representative Sewell has held several leadership posts, including freshman class president in the 112th Congress. It feels like forever ago. And also now in the 117th Congress, she was selected by Democratic Whip James Clyburn to serve as Chief Deputy Whip. And she sits also on the prestigious Steering and Policy Committee, which sets policy direction for the Democratic caucus. So she's not just occupying a seat. You've seen her on television, you've seen her on C-SPAN, you've seen her in communities. I give you Congresswoman Terry Sewell, our first special guest for today. Welcome, Congresswoman Sewell.
Thank you so much, Damien. It's an honor really to be among such auspicious guests and to really try to tackle in a conversation format voting rights. Nothing could be more timely than to discuss voting rights at this juncture in American history.
Without question, as we've thought about it, as I said at the Lawyers Committee, democracy itself is under attack, but let's make that real for folks. So you are, of course, a native of Selma. We all know the history of the Selma to Montgomery March on Bloody Sunday and the crossing of the Eben Pettus Bridge and the Jubilee that happens every year. Our team's last big group trip, a dozen of us, including a board member, were in Selma with you and so many others, especially when all the candidates were there to take advantage of that opportunity back in late February of 2020, just before the pandemic. So much has changed and so much has not. Can you just talk to our audience about the contemporary fight for voting rights beyond what they see from the black and white photos and the historic landmarks and historic events?
Well, as you rightfully said, I am a native of my home. This is my home district. To have a full circle moment to be able to be an intern for my member of Congress way back when I was in college to now holding this very same seat. I would have never thought as a girl growing up in Selma, and I'm a lifetime member of Brown Chapel AME Church, where all the marchers would gather during Jubilee to remind us never to forget Bloody Sunday and the fact that what goes around can come around, and old battles have become new again. If you had told me when I was a little girl in Selma that I would be a member of Congress and be able to call John Lewis colleague, I would have said no. But if you had told me that I would, 56 years later, have to take up the cause of the foot soldiers who marched in Selma during the Bloody Sunday, I would have definitely said no. But old battles have become new again. No longer are we having to count how many marbles are in a jar, but the types of anti-voter, suppressive actions that are being taken by state legislatures across this country is no less pernicious than those literacy tests and those other kinds of tests. They're modern day barriers to voting. And we've seen since the 2020 election, ostensibly one of the most fair and well participated elections in our lifetime, we've seen state legislatures across this country introduce over 400 bills that would be voter suppression bills across 30 or so states. And we've seen 18 of those states actually pass those bills, including Georgia, including Texas and some others. And these modern day forms of suppression laws include closing polling stations in minority neighborhoods, often without notice, limiting early voting and mail-in voting, which have been shown to be, those souls to the polls have been the most effective, as well as mail-in balloting, very effective tools in the toolkit. We've also seen them create strict voter ID laws. The state of Alabama, for example, we used to be able to vote with a validly issued federal ID called a Social Security card. Everybody has one. To now, all of a sudden, an acceptable form of photo ID is a hunting license or a fishing license, and not a student ID, even at the University of Alabama. So we're seeing a real onslaught of voting rights all across this nation. And when we think about the most seminal piece of legislation ever passed by Congress, the most consequential, the Voting Rights Act of 1965, also being under attack by the Supreme Court, gutted Section 5, the preclearance provisions, by finding unconstitutional Section 4, which was a preclearance coverage formula. In 2013, we have just seen an all-out onslaught against voting rights. And I dare say nothing is more critical to our democracy, to the promise of our democracy, than the right of every American to have access to the ballot box and to make sure that their vote is counted.
Without question. And Congresswoman Sewell, the measures that you've talked about in these voter suppression bills, some people wonder why we say they're, voter suppression, why they're discriminatory. In the litigation we filed, we've called the thing what it is. We have alleged intentional racial discrimination. And that's in large part because the methods that these bills are attacking, the voting methods, are the precise methods that communities of color are now starting to use with great degrees of sophistication. And there's such irony. There have been times in the past when, at least in certain jurisdictions, where Black voters, for example, tended to vote more in person than by mail. But of course, in the midst of a pandemic, you will vote by mail, you will vote early, you will vote drive-through in Harris County, Texas, for example, as much as you can to keep you and yours safe. And it's those very methods where you see this expanding electorate of growing interest and growing stakeholdership in our democracy, where they're trying to drown it out. And of course, you mentioned the Supreme Court's decision, the 2013 decision in Shelby County versus Holder, and being there that day, for the argument, and then being deflated when the decision came down. We know that we're not at a fixed moment in time, that there was certainly, constitutional interpretation, but there can be a legislative fix here, right, to address the alleged constitutional defects that the Supreme Court found in the prior preclearance formula. Important to note that, as you said, it was Section 4, not Section 5 itself, although we all fear that could be next on the horizon. But you shepherded legislation last Congress and this Congress that you got through the passage in the Senate in prime position, the John Lewis Voting Rights Advancement Act. I'd like you just to talk a bit just about, John Lewis, and it should go without saying, but I want to give you a chance to share why you have named the bill in his honor, but also talk to us about some of the key components of the legislation, what it will fix, and how it might even go further than just fixing what the Supreme Court broke in Shelby County.
Yeah, well, I think that it's aptly named the John Robert Lewis Voting Rights Advancement Act, because no single individual has done more to try to advance, voting rights in America than John. He said that the right to vote is precious. It's almost sacred. And I think that if we close our eyes, we can hear him say over and over again that we need to get into good trouble. When we see something that's not right and not just, we have to do something about it. For me, growing up in Selma, Alabama, and seeing these foot soldiers like John Lewis, like C.T. Vivian, like so many, come back year after year after year to the church to remind us of the importance of preserving the progress of the past, but also advancing it. And so the reason why we call it the Voting Rights Advancement Act, the John Robert Lewis Advancement Act, is because H.R. 4 and now S4, which has been introduced by Senator Leahy on the Senate side, does sort of three things. First, it restores Section 4 by giving a new coverage formula. It has a look back year of 25 years. So we're not talking about the 1960s or the 1950s. We're talking about 1995 going forward, and looking at states and jurisdictions that have had a recent history of discrimination, of voter discrimination, and requiring those jurisdictions to have their laws pre-cleared. And secondly, not only do we restore Section 4, but we also deal with the Bronovich versus DNC case that came out of Arizona just this summer, and try to strengthen Section 2, because that went to the very heart of Section 2. And of course, the Lawyers Committee was critically important in trying to help us come up with the retro regression analysis that was so critically important to that part. So first, we're going to restore the full protections of the Voting Rights Act. And secondly, we're going to also require a nationwide pre-clearance for what we're calling known practices. And these are the kind of practices that historically have been found to be discriminatory, like reduction in multi-language voting materials, or the creation of at-large elections, at-large districts instead of district by district. So we'll have sort of the geographical test and then a known practices test. And we go, because we call it the advancement, we advance by doing this sort of nationwide pre-clearance for known practices. And of course, we strengthen the election transparency. So HR 4 is an ambitious but very necessary piece of legislation, which is narrowly tailored to deal with what the Supreme Court told us in the Shelby versus Holder decision. Only Congress can come up with a new coverage formula. Only Congress can put the teeth really back into pre-clearance. And so that's exactly what HR 4 does. Of course, we also introduced in Congress HR 1, which was a For the People Act, which is much more advanced, much more, it was a larger bill trying to get at not just, access issues, but also to get at big money and redistricting and other things. So it was a much more ambitious bill, HR 1 was. HR 4 narrowly tailored to just restore and advance the Voting Rights Act of 1965. So I know we can get into the nitty gritty of it, but as you rightfully said, I've actually been introducing this not just in the last 2 Congresses, but the last 4 Congresses since the Shelby versus Holder decision. I've introduced it in 2014 and each successive Congress after that. And, you know, I think that there's no more critical piece of legislation that must get past the Senate than HR 4 or S4. And of course, we have big stumbling blocks with this procedural rule known as the filibuster. Right. And the reality is that unless we reform the filibuster, which a majority of the senators, all Democrats, can do if all 50 of them plus the vice president choose to reform the rules, the procedural rules, so that we can get past that hurdle and get a vote on the floor of the Senate and get this bill passed and signed into law.
I'm so glad you mentioned filibuster, and we'll return to more about the bill in a minute rather. But what we actually had Senator Cory Booker join us for our Lawyers Committee board meeting not long ago, just a few weeks ago, and we had a frank discussion, inside discussion about the filibuster. I won't repeat all the things that he said, but you were in touch with colleagues on the Hill across geographies, also within strong alliances such as the Congressional Black Caucus, of course. And, from the outside, we're seeing, signs of new energy and possibility for what you might call a carve out on the filibuster for democracy preservative legislation that's critical, mission critical here. You're obviously on the House side. You've in some ways done your work. You've done your job.
I mean, we passed it on a vote. It was a party line vote, but we passed it out of the House in August on a vote of 219 to 213. And we're proud of that. We also passed it in 2019 when John Lewis was still with us. We passed it. But it sits languishing on the Senate side as it did last Congress.
Right. So look, what do you have a prognosis for what will happen next? Or how things will pan out? In any, I won't say predictions, but any thoughts about what will happen?
Well, Damon, I think that the most important thing that we can do is to put pressure on the Senate to do the right thing. Mm-hmm. Very rarely does progress happen in the halls of Congress. It is usually happens on grassroots activism from organizations such as your organization, really pushing to get the senators to do the right thing. And now more than ever, we need that mobilization and that grassroots activism to really lead the way on convincing Joe Manchin and Senator Sinema and others of the mission critical ness of making sure that we at least address the filibuster when it comes to democratic, small d, preservative measures such as HR 4 or S4. And so, I think that without that, minus the efforts to mobilize and to really, put pressure on our senators, it will languish like the George Floyd Justice and Policing Act will. I mean, the filibuster is an archaic procedural rule that really grew out of segregation. I mean, we don't have to get into the whole ins and outs of that. But now more than ever, our Democratic colleagues must reform the filibuster. Or at least I know, that if the hands of Mitch McConnell, if he had a slim majority like we have in the Senate, he without a question would, I think, reform or really override the filibuster rule. I think it is a shame that it only takes 51 votes to put a Supreme Court justice in a lifetime seat. And yet we can't pass critical legislation like the John Robert Lewis Voting Rights Act without overcoming a 60 vote procedural rule.
Well, they say power concedes nothing without a demand, but also what is power if you don't use it? It atrophies and it dies.
Absolutely.
So let me quickly pivot to a couple of other issues before we open it up to a few limited questions from the audience. Just about the politics. There's been this odd perversion lately where that I think has been invited by the US Supreme Court, wherein we're told, well, it's not racist, it's just partisan. It's not discrimination, it's just party politics as usual. And so we see in these voter suppression bills around the country kind of discriminatory legislation masking as, partisan first legislation. And that narrative being driven of, well, if it's partisan, it's okay. And even in the Brnovich decision that you mentioned from the Supreme Court just this past June, even if it's a little bit of discrimination, it's okay, right? And so it's almost as if our threshold or tolerance for voter suppression, for discrimination, we're being invited to have a higher tolerance for that. But just on the partisan side of things, the last time the VRA, the Voting Rights Act itself, was reauthorized in 2006, it was under a Republican administration, George W. Bush. The time before that, in 1982, one of my mentors, Lonnie Guinier, was there involved in the process. It was also, a favorable vote in the Republican administration, Ronald Reagan, and before that as well.
So it's been reauthorized 5 times, like you said, and most
times.
recently in 2006, it was unanimously out in 2006, voted out of the Senate. And but for the Shelby versus Holder decision, we would still be living under it because it was a 25-year authorization.
Right. So what happened? Why is it that all the Republicans, all the Democrats could easily fall in the line in 2006, a year or so ahead of schedule, if I recall correctly, right before expiration? But why is it so difficult now to even get a vote, period?
Well, you know that Republicans have decided that by limiting the access to the ballot box, they can determine elections and flip them in their favor. And so while voting rights should be a nonpartisan issue, it truly should be. If you're an elected official, you should not be in the business of choosing your own voters, but rather the other way around. The voters should be able to choose their own elected officials. And so there really isn't any reason why they're putting up these kinds of barriers other than they're trying to influence who goes to the polls, who has easy access to the polls, and who has a harder time getting to the polls. What I want, and I know your audience knows this, but I hear young people say, well, I have the right to vote, but my vote doesn't matter. Well, if we saw anything with Georgia, the Senate, 2 Senate races in Georgia that now got us a Black and a Jewish senator in Georgia. And Georgia also flipped this presidential election. Our vote matters, and everyone's vote must be counted in order for us to really be able to make decisive decisions about our future. The vote is critical. It determines the air we breathe, the water we drink with Flint. The vote is critically important. And so every vote matters. And we have to really insist that we make sure that this process is opened up to everyone. I can remember when Alabama changed its laws and it made it much more critically important that you have a driver's license. And in the very same year, the governor closed down DMVs in Black areas. If that wasn't an effort to limit the ability of some people to vote, what is? And so we have to be just as vigilant as our foremothers and forefathers were in our efforts to try to overcome this voter suppression. And I think in the short term, that means all of us need to know our state's rules and laws and make sure that our folks are getting out to the polls with the proper ID in order to vote. And it also means that we in Congress have to do our part by restoring federal oversight for the most egregious actors. The reality is, I would love it if we had federal oversight over all 50 states and every territory, to be honest with you. But we know that that's an expensive proposition, and the Supreme Court has said that states' rights should prevail, except for in very narrowly tailored efforts. And so, a 6-3 majority in the Supreme Court is just chomping at the bit to get to the Voting Rights Act, and we have to do everything we can to preserve it and to advance it.
Thank you. Well, let's invite a couple of questions that are stacked here in the chat from our audience, and I may add another myself if we have time. But one question is about the Senate version of this critical legislation. Are there important things we should be watching for, important differences? And then also any further comment on the legislation that Senator Joe Manchin has introduced, which has not been fully endorsed by the civil rights community, but certainly has some interesting provisions that we're all watching.
Yeah. So, I think right now the version of the bill that has been dropped on the Senate side is exactly the version that we passed on the House. But I fully expect, in order for us to get all 50 Democratic senators on board and have a ghost of a chance of getting maybe the senator from Alaska to come in, we're going to have to either change the look back year. Instead of 25 years, look at maybe 20 years or 15 years. Joe Manchin has also said that he has a problem with us using consent decrees as an adjudicated violation in states and jurisdictions being able to rack up the requisite number of violations in order to be subject to preclearance. And so there are a number of things that I think that may, in the making of the sausage, if you will, change on the Senate side. And frankly, while I do not want the consent decrees to go away, because I know many Southern states have consent decrees that should serve as a statewide violation, I think that right now the most important is to get the teeth back in. Better to get some federal oversight than no federal oversight. And so I fully expect that there will be some negotiations going on. When Sensenbrenner and Conyers came up with a bill right after the Shelby versus Holder decision, they also took out the known practices. Now, look, I wasn't going to negotiate against myself. I think that the bill that came out of the House and the bill that's currently in the Senate is exactly the bill that should get passed. But we all know that in the making of this sausage, that some things may go away. I think that we need a nationwide preclearance on certain provisions that have shown themselves to be discriminatory, prima facie discriminatory. But I'm looking for those kinds of things to change. And likewise, you mentioned a bill that just came out of rules that Amy Klobuchar and Manchin and some others really kind of pared down what was S1, the For the People Act. They introduced 3 weeks ago now, the Freedom to Vote Act, which really stripped a lot of very important provisions dealing with redistricting, dealing with dark money out of it, and really focused more on the John Lewis Empowerment Act portion of S1 and dealt with access issues and introduced it. And apparently Manchin actually signed off on that version and signed on to that bill, the Freedom to Vote Act. I want anything that's smoking out of the Senate to get the vote to the desk of Joe Biden. We can't make the perfect be the enemy of the good. I know we've all heard that, but now more than ever, we need to put, we have to have a foothold into federal oversight, because the states are going amok right now without it.
Right. Well, as your colleague, Jim Clyburn, reminded us in the meeting not long ago, unity doesn't have to mean uniformity. And I hear a real politic coming from you in terms of your perspective. And I think we should take note of that for you as a native Alabamian and also a diehard, dyed-in-the-wool civil rights person. I think it's an important perspective. Look, we're at time for your segment. I know you have to run, but tell us, one of the audience members wants to know, what can we do now? Not just civil rights infrastructure and organizations, but everyday lawyers, everyday non-lawyers who are advocates and people of good conscience. What can we do right now?
Obviously mobilize. I cannot thank the Lawyers Committee and all the lawyers who have gotten us to this point. When I think about the fact that we've been doing without Section 4 and therefore Section 5 since 2013, and really we've only been able to litigate Section 2 claims, and the fact that you all are doing it and are continuing to do it is critically important. The election protection efforts that lawyers do across this nation, critically important, and we must continue to do that. But we also need to speak power to truth. I think sometimes we get bogged down in, whether it's HR 1 or HR 4 or the freedom. Let's just talk about the fact that our democracy hinges, the promise of our democracy hinges on the right of every American to vote. And let's go out there and do all that we can to do that. When I think about what spurs me on, even in the darkest of moments, because, I don't have control over the Senate. I don't even have control over the discussions that are going on among the senators and what ultimately will come out. What I do know for a fact is that something has to give. Right. And we have to be willing to do our if our foremothers and forefathers did the fight, we have to take a play out of their playbook. They were not just, by happenstance in Selma, Alabama. They were strategists and tacticians. And one of them was Amelia Boynton Robinson. And she reminded me so much, and reminded all of us so much, when people would come up to her and say, we stand on your shoulders, Miss Amelia, she would say, get off my shoulders, do your own work. Right. And so often we all love to say that we stand on the shoulders of giants. What's now our turn to pick up that baton and continue the race. Every generation has to fight to maintain the progress of the past and to advance it. This is now our cause, and we should do all that we can in our power. If that means as a legislator, me legislating, you all as lawyers, you all doing your part, but also let's make sure that we let folks understand in their various jurisdiction what is required to go to the polls and vote, and let us vote like we've never voted before.
Thanks so much. That's exactly what we do throughout the year for election protection, 866-hour vote, the hotline, the online presence, and what have you. And we appreciate your partnership. We're a nonpartisan organization, but we recognize talent and leadership when we see it. And you certainly exhibit that. Congresswoman Terry Sewell, thanks so much for joining us today.
Thank you. Thanks again for the invitation.
Take care. Bye-bye. So audience, Congresswoman Sewell set this up perfectly. She talked about what we can do to mobilize. And at the Lawyers Committee, we work in multiple modalities. Our team internally, we've talked about mobilizing in Congress and the halls of power, mobilizing in the courts as we do in our fine litigation, but also mobilizing in communities. And so we've talked about the Congress part of it. To talk about the other two pieces, I want to introduce my great colleagues, Marcia Johnson Blanco and Ezra Rosenberg, who are co-directors of our Voting Rights Project at the Lawyers Committee. They in turn will introduce additional guests, Gary Bledsoe of Texas and Jerry Gonzalez of Georgia, and talk about their fine work and perspectives from the front lines in their states and communities. But take it away, Ezra and Marcia. Talk to us about what we call Democracy Summer at the Lawyers Committee this past summer, and also voting rights litigation that we've been engaged in over this year plus.
I think I learned by now to unmute myself. Thank you, Damon. Yes, the Democracy Summer that we saw was basically building on the legacy of the civil rights movement and all the activists that we have seen in the past who've really pushed our Congress to act. And that's what we saw happen this past summer. It was a lot of activists, community leaders, and just citizens making the case for voting rights. And it was very much needed, particularly after what we saw in the aftermath of the 2020 election, and particularly on January 6th, which is still resonating, which is that, we really need to get in the streets and fight for a democracy, and also make really concrete asks of our leaders, not just on the federal level, but particularly in light of what we've been seeing in the states, where we've seen over 400 bills introduced in 49 states to restrict the right to vote. And we're going to be hearing about two of those significant bills shortly with our friends and colleagues from Texas and Georgia. Now, this past summer, I had the privilege of meeting a family that took part in the freedom rides that occurred this summer to raise awareness about voting rights. And this was a family that rode from Arizona to DC to meet at the steps of the Supreme Court for a rally. And, spending days on a bus. And that was, what was important. It was very important to them to do that, for the parents to engage their children in the right to vote and what it means. And it was at once inspirational to see that, but also really a bit depressing that we're at this state right now in our democracy where we have to increasingly take part in these actions to promote and push for voting rights. We also saw members of the Black Women's Roundtable getting arrested in speaking out for voting rights, and then getting invited to the White House for a discussion with the president, who, the message there has been not only pushing for the bills in the Congress, but also really pushing activists such as us to really raise the temperature on the right to vote. And then we saw the anniversary of the March on Washington this summer being used to again lift up the push for the right to vote. There was a lot of activity happening this summer as part of Democracy Summer, but we can't just let it stay in the summer. As we move into the fall, our voices really need to continue to be heard, not just in the elections that are happening, in municipal elections that are happening and statewide in some states across the country, but members of Congress really need to hear from us continuously to make sure that there's passage of the two bills that you discussed with Congresswoman Sewell. And with that, I'll turn it over to Ezra to talk a bit about the litigation that's happening before we talk to our state partners.
Thanks, Marcia. And I do want to talk about Georgia and Texas and a little bit about Brnovich. And using what Representative Sewell noted, that in Georgia, for example, where you had very close elections, but it was the voters of color who made the difference in electing 2 senators and electing a president with real, very, very close races. So what happened in Georgia? The Georgia legislature immediately took steps to try to make it harder for voters of color to use virtually every way of voting, such as absentee ballots, which in the past, white voters had been using at a greater proportion than Black voters and other voters of color. But in the more recent elections, voters of color had started to use absentee ballots more and more. So what did they do? They made it harder in SB 202, which was a bill that was passed in March, made it harder to vote by absentee ballot by placing burdens on submitting the ballots. You have to submit a copy of a voter ID. It's not always easy for people who don't have access to printers or computers to do so. They cut the deadline for applications and made it more difficult to distribute absentee ballot requests. They made it harder to vote by drop box, which is important for people who don't have the time to take off from work to vote. And they even targeted voting in person by prohibiting the provision of food and drink to people who are voting in line, who are waiting in line to vote. In Texas, you had the same story. In Texas, you have a situation where there's soon going to be a majority minority citizen of voting age population. And there, the Texas legislature has taken similar steps, prohibiting drop boxes, putting restrictions on early voting, putting additional burdens on absentee ballots, and perhaps the most pernicious thing, giving more flexibility and opportunities for partisan poll watchers to intimidate voters, while at the same time tying the hands of election officials from stopping these partisan poll watchers from obstructing the right to vote. We at the Lawyers Committee filed suit in both Georgia and Texas. We're lucky to have with us one of our clients in the Georgia case, Jerry Gonzalez, the executive director of Galeo, the Georgia Association of Latino Elected Officials. Other clients include the Georgia NAACP and Georgia in Common Cause and the League of Women Voters of Georgia and the Georgia Coalition for People's Agenda, for People's Agenda. As Damon mentioned, our thrust of that case is that this was intentional discrimination on the part of Georgia. That case is pending in the Northern District of Georgia. In Texas, on behalf of Texas NAACP, and you'll soon be meeting its president, Gary Bledsoe, has been president of Texas NAACP since 1991. We have filed suit on behalf of Texas NAACP and Common Cause of Texas and individual election officials and voter assisters who are individually impacted by these new laws. We have filed that in state court in Harris County of Texas, and that case is pending. Briefly on Brnovich, which is the United States Supreme Court decision that Representative Sewell mentioned. In Shelby, the Supreme Court gutted Section 5 of the Voting Rights Act. And in the Brnovich decision, while they didn't gut Section 2, they certainly made it more difficult for voters of color to prove that their rights are being discriminated against. Justice Alito, on behalf of a divided court, put up what he called guideposts to guide the decision in voting rights cases under Section 2 of the Voting Rights Act. One of them, for example, is the degree to which the voting rights provision that's challenged is different from what was in place in 1982, as if 1982 should be the guide. Well, we know that people who want to suppress the right to vote, or the right to vote, change with the times. There were literacy tests, so they replaced that with poll taxes. There were poll taxes that replaced it with all white primaries. And then they did even more and more subtle, but equally pernicious things to suppress the right to vote. So it's important that the so-called guideposts in Brnovich be rejected by Congress, which has the ability to do that, and clarify that what the Brnovich court did was not in line with the intent of Congress. And we're hoping that the provisions of the Voting Rights Advancement Act that do just that are passed. And with that, I will pass it back to you, Marcia, for perhaps starting the questions and answer part of this program.
Thanks, Ezra. Invite Gary and Jerry to turn their videos on, and we can start the conversation about not just what's happening in their states, but just really drilling down a bit more specifically on the impact of the laws that Ezra just mentioned. I'll start with Jerry first. Thank you so much for joining us, and wanted to hear from you about what is your biggest concern about SB 202 and specifically how it's impacting the Latinx community there in Georgia.
Thank you, Marcia. It's really important. SB 202 is really took a very hard look at how minority communities participated in the 2020 election cycle, and specifically targeted minority communities' access in that way by making it much more difficult for communities of color in particular, to access those mechanisms of really casting their votes in the 2020 election. Example, the big one that comes to mind that Ezra mentioned as well was the giving food and water to individuals waiting in line to vote. Well, those that were waiting in line to vote were typically in majority non-white precincts that had to wait in tremendous lines all over the metro Atlanta area and in other places around the state. So that's a big one because it will limit it will discourage voters from waiting in really long lines. Some of the lines were even like 8 hours long in them being able to cast their ballots in the 2020 election cycle. The other concern is the restrictions on absentee ballots and how nonpartisan nonprofit organizations like ourselves are able to provide that information to voters that need it, particularly in the language that they need it to. There's only one county that's required to provide bilingual information in Georgia, and that's Gwinnett County. All the rest of 158 counties, and the Latino community is widespread all over the state. They don't have access to language access, and all of the absentee ballot information, and confusing absentee ballot application process is only in English to start. So not only that, there's copies required for submitting your absentee. You have to make a copy of your ID in order to submit with your absentee ballot and submit with your actual ballot once you send it in. Many people in our community don't have access to technology like that, printers and copiers at home, that they'd be able to print off multiple copies of their IDs in order for them to be able to vote in absentee. And what is that puts our community in a situation where they have to show up in person. And if it's a non-white majority precinct, again, the lines are going to be long and it's going to discourage people from voting. So it is a potential for that. Drop boxes were a big thing in 2020, and they targeted those as well. Drop boxes were limited to now to early voting locations only, and usually they're only open during office hours, which means that many in our community that work 2 or 3 jobs are not going to be able to access the drop boxes because they're only open and accessible during regular office hours. It is another concern that we have is the invitation to have unlimited challenges to the right of any voter to register and cast a vote. We saw some of that funny business happen several years ago in 2 counties in South Georgia, where all Latinos were challenged to vote, challenge their legitimacy for voting in elections just simply because of their last names. The DOJ at that time got involved and was able to address that situation, but we're concerned about these unmitigated challenges that voters can bring against particularly targeting communities of color just because of their last names. And the other piece that's very concerning to us is the ability for the state to take over elections boards. Right now, the state is making movement to take over Fulton County, and Fulton County is a minority-rich urban area that certainly is a big concern for many in our community about the state legislature taking it over simply for partisan advantage and trying to do the things that President Trump was wanting to commit in fraud in the last election of finding a few extra thousand votes for him to take over the legitimate votes cast by voters in Georgia in the last election. So there's a lot of concerns with SB 202 that we have, and those are just some of the ones that I wanted to mention and highlight in our processes.
Thank you, Jerry. Just a parade of horribles there. Turn it to Gary. You know, Gary, Texas was very much in the news because the legislature went to extraordinary lengths to be able to pass SB 1. Can you talk a bit about how, you know, the passage and the provisions of that bill fits into the context of how voters of color have been treated in Texas? And your main concerns there about the bill.
Marcia, thank you so much. And I want to thank Ezra, Damon, and the whole group. You guys do outstanding work, and you have big fans down here in Texas for the work you do. And thank you for all the support you've given us in the past and continue to do. I see this as the minority community being under siege in Texas. And I think that people need to understand that Texas is a bellwether for what's about to happen in the country, and the whole dynamic with January 6th and the refusal to acknowledge the election results from 2020. That's what we're seeing here. What's occurring in Texas, as Ezra mentioned earlier, is that we're clearly evolving into a majority-minority situation. We've already reached that in terms of voting age population and in terms of total population. The white Anglos here are very much well below 45%. However, in the voting age population, citizen voting age population, is about a 51-49 in favor of the white population, but that's almost even. And so there's a real paranoia here about the transition to minority sharing power, taking over power. And so that's what we saw taking place before the Texas legislature. And we've had voter suppression efforts every single session of the Texas legislature, probably since the passage of the Voting Rights Act. Even when Democrats were in control, sadly, it's taken on a heightened sense of activity since the Republicans have taken over here back in the late 90s. But we can point to every session, even before when Democrats were in control, to show there were these problems. But this year, it's different. The legislation that was promulgated was so broad, so vast, so protracted that it was intending to make sure that white voters would be able to continually dominate in our state, despite the fact that you see them having diminishing numbers. So, what they intended to do by this bill is to Stacey Abrams proof our state. They wanted to make it so extreme that you can't have effective organization skills to go out there and organize and have your voters to elect the candidates of their choice. And it's really pervasive and comprehensive. It starts from the beginning in terms of there are all kinds of mechanisms in the bill to address voter registration and allow for referrals and potential prosecutions of individuals for voter registration issues where you're now having interfacing data between the Department of Public Safety registration data and the addresses on your voter registrations. We've seen how things like this have led to incredible purges in other states, and well, they're doing it here. And I think we all know, especially when we're younger, that we may move from place to place. We may forget to change one of our addresses. So we're not trying to defraud anybody, but we may have a different address. That's one of the mechanisms that's going to be utilized. And it's not just the whole before factor, because it goes into your organizations and how you get out the vote. And it creates causes of action and criminal conduct for what's called vote harvesting. They try to make good, honest, traditional work and going out and trying to get your neighbor elected into something criminal. The law is so vast now that if you decide that your church is going to go out and support a specific candidate, and they go out and tell people to vote for a specific candidate, and one of those persons has requested an absentee ballot that happens to be in their home, then you would have committed a felony offense simply by asking them to vote for a specific individual if you're paid. And it doesn't say what pay is, right? So it's intending to throw a real wrinkle into how you get out the vote, into how you organize. It also addresses issues in terms of the early voting, where they limit the voting, because what we've been able to determine is that African Americans and Latinos primarily are the ones, because of the jobs, et cetera, that use those after hours provisions to go in and vote. But they can't do this now with the new bill. You have to shut down at 11 o'clock at night, I guess, and not open up before 6 a.m. in the morning. They even limit the time for the souls to the polls on Sundays. So those things are clearly and masterfully designed to limit our participation. They limit the type of venue where you can have early voting, when you can be enterprising like Harris County was this last time, and you set up mobile stations that are just as secure as any other station. You can't do that any longer under this law. And further, to place an incredible burden on the authorities, what they're doing is, they said, if you have an office, the registrar has an office anywhere in the county, you have to make sure that's an early voting site. And so that means that you don't have unlimited resources. You can't hire unlimited people. And so you've got to use that as a site, even if it's not convenient. It gives you an alternative site, as if there's not enough room in that. It allows you to go and get use otherwise in the building. So if they're leasing from someone else that owns a building, you've got to go somewhere else in that building and lease something, but you can't go out and get a good solid structure and put something there. I think it's outrageous what they're doing. I think not only that, the whole issue with mail-in balloting, where we had a good law where they had reached a balance and interpretation. Even our Republican Supreme Court had reached a reasonable decision this last late June in the middle of the pandemic, and they thought that was too reasonable. So they made it much more difficult. You've got to have signatures that are provided to request ballots now. You've got to make sure when you request a ballot that you disclose or give them very private information that I would have concerns with. We saw all the issues, for example, with if you guys remember the Kobach Commission under President Trump when he started, and the real desire to get that kind of sensitive data. Well, they're requiring that everybody give up that sensitive data now if you want to vote absentee. And I have a real concern about the use of that data once they get it. And you know, that even has other implications that actually affect foreign policy and national security, because you know, especially in areas like when I've talked to military officials that were going to support us in the previous litigation that Ezra might recall. And so, you know, there are a lot of issues there that we have to peel back. They're making it very difficult for people. They're making it difficult in terms of your handwriting, where they can disqualify your mail-in ballot application. They're making it difficult for people to help you because they've got to swear out affidavits about what they said to you and things like that. And they can interface that with the requirements that you disclose. And so they can theoretically turn the individual who wants to be the Good Samaritan against the individual they're trying to help. It's really kind of wicked in the way they're actually doing it. And you go to the election day, right? We move on to election day. You know, we've had such an enormous problem in Texas with racist poll watchers. If any of you have seen the Common Cause video where they're doing the training session in Harris County, they don't use the N-word, but you know, you don't have to be a genius to understand that this is bigotry 101 that they're talking about in terms of how they were going to handle their work and sending people out into the African American community to address voting issues. I think they indicated in the training that they have to get together a brigade because of how people are down here and things like that. Various code words that just really spoke out to me as very clear about what they were doing. And so now the racist poll watchers this last time got into disputes with African American female election judges who wouldn't allow them to do their misdeeds. And so what happened was they did us one better. They went to their friends in the legislature, got a law passed, empowering them, putting them above the power of the local election judge. So the African American females will no longer have the power to control these guys, and they have the right to look, see, and hear about what the voter is doing. I think they clearly will violate rights of privacy. They will really create long lines and just basically wreak havoc. And the interesting thing was they threw a bone at us in the bill, because they threw a bone to say that an election judge can go out and get an injunction or a writ of mandamus. But, you know, everybody else, there are probably 30, 40 new criminal laws that are provided in this new bill. But there's no criminal law that is associated with the misdeeds of these guys that we've known to engage in such bigoted work. And just think about, you're an election judge and these guys do the misdeeds. And so, number one, where are you going to find a lawyer that's going to go out and file this? And the lawyer's got to go find an available judge. How much time will transpire? How much misconduct will the individual engage in while they're at the polling place? It's really abominable what's allowed. And you know, they have empowered the early vote balloting board in terms of disqualifying signatures, giving them access to more signatures to disqualify signatures for the mail-in voting ballot. So we think that's truly problematic, because we've seen elections in the past, like African American judicial candidate Goodwill Pierre in Harris County back in 2008 was one of only 3 candidates that were Democratic that lost, and it was pretty obvious that was some biased voting. But there were thousands of ballots for Goodwill Pierre that were discounted, and at that time the Republican Party was in control of the early vote balloting board. And so, but it goes. That's just a few. I know we're talking about Texas and Georgia, so I'll be quiet. But there's so much more in the bill in terms of what they've done, and they intended to make it really difficult for us to win any kind of election. They've even created. I'll mention one more thing. It's kind of similar to the new anti-abortion law that they passed. It kind of gives a private right of action for people to get out there and litigate against candidates and supporters of candidates that they don't like and claim did something nefarious that somehow injured some right they had under the election code. And so you can have all these new nefarious actions that are out there that can now be filed based upon a new cause of action that's provided for in this new bill. So I think it's really outrageous, intending to intimidate voters all around, and it's going to be an enormous problem for us. But some of the things that are so obviously discriminatory and illegal or unconstitutional that we hope the courts have at least the wherewithal to go with those and invalidate those. And there's one more I should mention. There's the one bill that says if there's any established custom, policy or procedure or practice that has the basis of foundation in law, that an election worker commits a crime for not continuing with that custom, practice, policy or procedure. Now, how in the world is an election official gonna know that? You're not a lawyer.
Thanks. Thanks,
So
Gary.
it's just outrageous, but it's
Yeah.
intended to intimidate people from wanting to be election judges.
So, we're at time, and I really hate for us to end, talking about all of the awful things that Texas and Georgia are doing without providing some bit of hope or, an action that we can use against this. And so I know that that's one of the things that Damon is really expert at is providing us with a hopeful charge forward. So I will turn things back over to him. But thank you, Jerry and Gary, for just putting some more meat on what we've been experiencing. Voters in your states have been experiencing with these new laws. Damon?
Thank you, Marcia. Thank you, Gary Bledsoe and Jerry Gonzalez. Time feels too short. We want to have you back in other forums. We want to get back together in person, when everyone can do that, because this is really a discourse that's years in the making. Gary, I've been watching you for so long. I won't name years to date anybody, but just through the NAACP and just your own, smarts, and having grown a generation of advocates, frankly, who followed you, and Jerry, getting to know the work that you're doing through our team. We'd love to build with you directly as well. Look, folks, this work, we talked about it earlier. What's at stake is power. What's at stake is the future of our democracy. And there are people who are willing to subvert it no matter what. There are, intricacies and nuances and differences from one state and one jurisdiction to the next. But what's clear is that it is really about the voice, the votes, and the vitality of Black people and brown people that's really being threatened here. And this kind of racism will undermine our entire democracy if we let it. And none of us are about to allow that to happen. That's why we're suing. That's why we're marching. That's why we're advocating. That's why we're supporting these types of efforts. So thank you, audience, so much for joining us. This will be one of the, a periodic series that we'll do webinar style. Can't wait to be with you in person. Reach out to us if you have info, intel, leads, things that we can follow up on. If not us, one of our great state or local partners or even national partners can do this, because we're all in this fight together for justice and racial justice at that. Thanks so much for joining us. We'll see you next time.
Thank you, Damon, for the great work you do and all your guys. You have a great team. Thank you guys for what you do.
Thank you, brother.
Thank you all.
Take care.